Hello. Welcome to the podcast today. This is Ralph's Law, where justice reigns. All right. I needed to do this video today. Fantastic day today, but I wanted to just finish up this video because it was part of my litigation series on. This is the opening statements. So I just needed to finish up this video because a lot of people actually wanted me to, finish it up and just like put it out there. All right. So the last video that I had, I stopped at the fact that you actually have to have a theme. Okay. So part of the whole thing in that is that make sure that the theme that you have is not a theme that the other side, the opposing counsel, can actually use against you. So be very careful in choosing your theme. You can choose. I mean, there are lots of simple stuff. Just choose it and just make sure that it works. It's workable. Okay. So that's how you do that. And another thing about it is make sure that when you talk, you have to speak in an active voice, not passive voice. Okay, so sometimes in trial, some attorneys actually talk in a passive voice. That's not very effective. You're better off talking in an active voice. Okay, that's how you present your case. That's how you get the jury, the jurors, members of the jury, to believe in what you're talking about. You have to talk in an active voice. So if you don't know how to do that, I don't know. I mean, you just have to figure out how to do it. But passive voice, no. Active voice, yes. All right. You need active voice. That's how you talk to the jury. All right. Okay. And then after you've done all that, the next thing that you have to do is just to introduce the burden of proof. So most likely, the judge is still gonna give them like the jury instructions on the burden of proof, but you still have to like preview that. So basically, what you're trying to set up is in a situation where, okay, let's say you're in a criminal, it's a situation where you're a defense attorney. You still want to mention that, just in case maybe the prosecution doesn't meet their burden of proof. Of course, the prosecution is supposed to meet their burden of proof if they prove the case beyond a reasonable doubt. And of course, if it's a civil case, maybe preponderance of the evidence or whatever. You want to mention that. You don't need to go into the details. You just want to mention that, kind of like just setting that up and leaving that so that in later on you can go back to that and say, hey, they didn't meet their burden of proof. So you're setting yourself up, you're setting the whole thing up for maybe your closing arguments. Okay, so just mention the burden of proof. That's actually very important in an opening statement. Okay, and if you feel like there are some kind of questions that they have or that can potentially be raised, whatever, answer those questions. And part of that will be acknowledge the weaknesses in your case. And this is what some attorneys don't do. So if you have a weakness in your case that potentially the other side is gonna use, acknowledge that. So the way to do it is this: acknowledge that and just say, hey, make it not to be such a big deal. So let's say I'm a criminal defense attorney and I'm defending a person that is a gangbanger. This guy's in a gang, right? That the other side is gonna use the fact that he's in a gang. They're gonna use that. So what are you gonna do? In your opening statement, just mention that, bring it up, that the person could be whatever in a gang, but he or she was in that situation because of all the stuff that happened, in their environment. So it's kind of like circumstantial evidence, but bring that up, and that's how you like take care of the whole situation. Acknowledge the weak parts of your case. When you acknowledge it and deal with it, it takes it takes off the sting that the other side will have on whatever is weak in your case. So you have to be able to do that in your opening statement, and that's actually necessary, okay? And then after you've done that, find a way to make your client, or the person that you're representing, if you're working in a DA's office, public defender's office, whatever, whoever you're representing, paint that person as the comeback kid. And that's, some people don't know this, but that's just how you do it. The comeback kid. People love the comeback kid. Ask Bill Clinton. The comeback kid, you come back, you're like, okay, this kid was in a gang, whatever, and he or she did all this bad stuff, but we are trying to tell you that they came back and they fixed a whole lot of stuff. That's beautiful. That's fantastic. And I'm telling you, most juries will reward that. The comeback kid. If you can make your client be that, you're golden. All right. So that's what I'm trying to talk about. So this whole thing is it's promises kept, promises made, promises kept. The final stage is the asking. What do you ask the jury for? Don't make the big ask. I want to call it more like a soft pitch. All right. You haven't presented the case yet, so don't tell them to just acquit your client. No, stop.